As they are awards rendered after an at least nominally consensual process, they are generally self-executing in the sense that the parties will comply with the decision of the tribunal. However, where the parties do not comply with the decision of the tribunal, resort may be had to the courts in the place where the award was given, in this case that would be Switzerland, or where action is sought to be taken on the basis of the award in any other place in the world. Since, as I mentioned, and as Bill Davidson mentioned, CAS tribunals are based in Lausanne and are necessarily based in Lausanne, CAS awards are subject to the curial supervision of the Swiss courts. Now, this has a number of consequences, only one of which I will mention today, and that is that any challenge to a CAS award, including any application for annulment, setting aside or revision, must be made to the Swiss courts. CAS award cannot be challenged in any other place. However, recognition and enforcement of a CAS award can be resisted in any place where such recognition or enforcement is sought. I'll now refer briefly to those matters. I will do so very briefly, hoping that many of you are familiar with this, but also conscious of not pressing too much upon your patience. First of all, challenges must be made in accordance with Swiss law, and the relevant Swiss law is the Federal Code of Private International Law. You've already heard a summary of the provisions, and I've set out the terms of those provisions in full on the slide that's now on your screen. The relevant provisions, so far as the case I'm going to look at, are the ones I've underlined. So those are the grounds on which an award may be challenged or an application brought to annul or set aside an award in Switzerland. As I also said, awards can be resisted in the sense of recognition and enforcement of the award being resisted in other places wherever recognition and enforcement is sought. Such challenges will almost invariably be made pursuant to the terms of the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. This has been acceded to by more than 160 countries, and even those countries which have not acceded to it apply a very similar regime. The terms on which recognition and enforcement of an award can be resisted are very similar to the grounds of challenge set out in the Swiss Private International Law Code, which we've just looked at. Again, I have those on the screen, and I've highlighted the particular provision that's going to be of interest when we come to the Bechstein case. And I now come to the Bechstein case. Claudia Bechstein is a German distance speed skater of great renown. She competed in six Winter Olympic Games between 1992 and 2014 and missed only the 2010 Games. She's won 5 gold medals, 2 silver and 2 bronze, and is the most successful Winter Olympic speed skater of all time. She was also the first female to win medals in 5 consecutive Winter Olympics. In addition, between 1996 and, to my mind, quite incredibly, 2015, so over a span of some 19 years, she's won 40 World Championship medals, including 6 gold. And she was, and still is, very much a darling of German sports. However, 2009 was not a good year for her. In February 2009, the International Skating Union, or the ISU, accused her of blood doping on the basis of a conclusion drawn from a discrete in-competition test, but also from blood profiling over an extended period of time, about 8 years, I believe. She was not accused of doping on the basis of an adverse test or a result showing the presence of a prohibited substance in her body. the ISU commenced disciplinary proceedings in March 2009 for breach of its anti-doping rules. Pechstein's response to the ISU, which was supported by the German Speed Skating Association, raised a large number of generally procedural whether proper protocols had been followed, whether there had been breaches in the chain of custody in relation to her samples and so on. She emphasised that she had not failed any specific drug test. However, in July 2019, the ISU's disciplinary commission upheld the complaint and banned Pechstein from competing for 2 years. The participation agreement signed by all athletes competing in ISU events provided that any appeal from a national disciplinary commission had to be made to the CAS. Pechstein so appealed, denying that she engaged in any form of doping. A CAS arbitral tribunal was constituted. No objection was raised by any party as to the composition of that tribunal, and in particular, no objection was raised to any member's independence and impartiality. Nor was any objection made to CAS's jurisdiction to determine the appeal. After conducting a fresh and complete rehearing, as required under the CAS rules, on 25th of November 2009, CAS issued its award and it upheld the ISU ban, confirming the doping finding against Pechstein. Significant for reasons outside the scope of my talk was it was the first time that CAS had upheld a case of doping in the absence of specific analytical evidence, but instead had relied on blood profiling. We might hear more about that later in the session on anti-doping. Subsequently, in February 2010, Pechstein made another challenge to the ISU award against her to CAS, but that was also rejected. In December 2009, Pechstein submitted an application to the Swiss courts for annulment of the award. It was a wide-ranging challenge. She alleged that the tribunal had not been properly constituted, that her right to be heard had been infringed, and that the decisions of the CAS tribunal were contrary to Swiss public policy on various grounds, principally because it contained inconsistencies in the reasoning, was obviously wrong, and did not contain full reasons. In February 2010, the Swiss court rejected the application for annulment of the CAS award. In particular, in relation to the challenge based on institutional bias within ICAS and CAS that affected the impartiality and independence of the tribunal, the Swiss court held the complaint to be inadmissible as Pechstein had failed to raise any complaint as to the composition of the tribunal before that tribunal, or indeed before CAS or ICAS. As for the challenge on the basis that the award was contrary to Swiss public policy, the court observed that there was in fact no significant public policy issue raised, and that Pechstein was merely seeking